Just gonna leave me here alone. Oh, we got some people joining. Bella, look. Got people looking at us. Say hi.
This matter comes on for a first appearance. Mr. Warwick, correct me if I'm wrong, but formal charges have not been filed yet?
That's correct, Your Honor. The defendant was arrested. Formal charges have not been filed. On my calculation, I believe it will be due to the court at 3:30 on Monday.
Thank you. Mr. Mercer, anything you would like to say about that?
Not regarding that issue, thank you.
So the court has reviewed a affidavit in support of a warrantless arrest. The court has found probable cause for the arrest. Specifically, I see that Mr. Watts was arrested for 3 counts of first-degree murder, each a Class 1 felony, and 3 counts of tampering with a deceased human body, each a Class 3 felony. Again, these are only charges that are named in the affidavit in support of a warrantless arrest. It's the district attorney's office who will ultimately decide what charges, if any, are going to be filed. And Mr. Mercer, would you like me to advise your client of his rights pursuant to Rule 5?
Yes, please.
Thank you. So, Mr. Watts, I would like you to listen carefully to the rights that you have, okay?
Thank you.
And so first, you don't need to make any statements. Any statements you make can and may be used against you. Do you understand?
Yes.
You have the right to counsel. Do you understand?
Yes, sir.
If you are indigent, you have the right to request the appointment of counsel or consult with a public defender before any further proceedings are held. Do you understand that?
Yes, sir.
And Mr. Merson is the head of the public defender's office, and he is going to represent you today and potentially in the future. Do you understand that?
Yes, sir.
Okay. Any plea that you make must be made voluntarily and not the result of undue influence or coercion. Do you understand that?
Yes, sir.
Right now, charges have not been filed, so this is a limited advisement. I intend to bring you back next week once formal charges are filed on Monday, so I can give you a full advisement. But I will tell you that at this point, the court is not authorizing any bail. Once I know what the official charges are that are filed by the district attorney's office, I'll inform you the nature of the charges. If charges are filed, you have the right to a jury trial, and you have the right to demand and receive a preliminary hearing within a reasonable time to determine whether probable cause exists to believe that you committed any of the charges that are filed by the district attorney's office. Do you understand that?
Yes, sir.
I believe that your lawyer has filed about 16 or so motions on your behalf, including a request for a preliminary hearing. Do you agree, Mr. Merson, that that time period, that 35 days to have a preliminary hearing, doesn't begin until your client appears in court next week once formal charges are filed?
I agree.
And I have not seen, correct me if I'm wrong, a proof positive, presumptive great written motion by your office.
Not at this point, Judge.
Okay. Okay. And so would you like me to further advise your client of any additional rights?
No, thank you.
Mr. Rourke, what kind of conditions, if any, are you requesting for the protection order given the circumstances?
Judge, I'm going to defer to Mr. Wren.
Mr. Wren?
People are simply asking for the standard protection order under Title 18 at this point, given the deceased nature of the victims.
And I assume based on the no bond hold, the issue of possessing or having access to or control over a firearm or any ammunition is a non-issue until and if bond is authorized.
That's correct.
Thank you. So, Mr. Watts, I am going to issue a protection order pursuant to Colorado Revised Statutes 18-1-1001. It's going to state that you not harass, molest, intimidate, retaliate against any witness involved in this case. Do you understand that?
Yes, sir.
If you were to violate the mandatory protection order, it's a Class 1 misdemeanor. Do you understand that?
Yes, sir.
And could we talk about some of them? I realize that things are happening very quickly. Motions were filed today. There hasn't been a lot of time to object or to file responses. Mr. Merson has filed a number of motions, some of which potentially may be time sensitive. My intention is for the parties to come back to court next Tuesday so I could advise Mr. Watts of his formal charges that are filed no later than 3:30 on Monday. So I'm not sure if I'm going to be requiring the prosecutor to file a response between now and Tuesday, whether we can resolve some of these issues now. For example, the preservation of certain evidence, like police notes, handwritten notes, like touch DNA evidence, things of that nature.
Your Honor, I think we can address some of these pretty quickly, but certainly not all of them. We would be asking for time to file a written response to some of them.
Yeah, I'm just concerned about the time that elapses between now and Tuesday, and I want to make sure that the evidence that's being requested to be preserved is preserved.
Understood.
So, for example, can you, any objection for me to order that all law enforcement, both state and federal, that were involved in this case, preserve their handwritten notes? Any objection to that?
No.
So I will grant that request. Did you read Mr. Merson's motion with regard to touch DNA?
I believe that was filed under seal, and I have not seen it.
It was suppressed, so they should have had access to it.
Gail, Christy, could you print out a copy for Mr. Red? Again, I appreciate the fact that this happened very quickly, and so let me get you a copy of that, a hard copy of that, and then you can review it and let me know what your thoughts are. Is there an autopsy that's scheduled to be conducted in the near future?
Not yet.
When is that, Judge? What motion is that?
It was a
16.
16?
Yes.
While we're waiting, Mr. Merson, I noticed that
Actually, I'm sorry to interrupt, Judge. It was D17.
D17?
Yeah, sorry.
so I see that your motions are numbered, but I'm missing 9 through 15.
Yeah, I basically counted them and then started off. There were some other people in my office that had filed those other pleadings and not numbered them.
I just want to make sure I'm not missing something.
I don't think you are. I think many of them many of them concern the media issue. On the way over here, the deputies advised the court had already ruled on that. So to a certain extent, some of that is moot. But if we are going to take a D17, in light of the fact that the affidavit is still sealed, I would ask that the court seal the courtroom and just allow the parties to argue that, because it will require me to talk about information in the affidavit.
Well, why don't we give Mr. Wren an opportunity and let me know whether, without talking about the substance, whether he has an objection or not. It's really more of putting the prosecution on notice than anything else. Why don't you read it first and let me know what you think.
This motion is...
You can give it to the prosecution.
Steve.
Extra.
I might. It was one of the... So, I did add the house to this, so the D17 will have the house on it as well. And that's the gist of it. At this point, I'm concerned about whether or not the house is still sealed off. It's not. It's been released by law enforcement. Okay. When was that? Late last night. Okay. All right. And I guess that part of the motion would be voted at this point. Mostly concerns what's in this motion. So,
If I could take a moment to read this.
Mr. Mercer, anything on the associated with the... Mr. Ring?
Thank you.
I'm okay with continuing it. I just don't want there to be any time-sensitive issues between now and next Tuesday that we should have handled today.
I think we need to address it today.
As I indicated, Judge, at this point, there's not an autopsy scheduled or autopsies. I don't know when that might happen. I don't know if it would happen before Tuesday or not. With respect to this motion, and does the court want to address Mr. Merson's concerns about clearing the courtroom, given the sealed nature of this, or may I speak for you?
Well, it was I think it's based on the sealing of the affidavit in support of the warrantless arrest, and so it was your motion to seal. So if you think the reasons why you requested the affidavit to be sealed are going to be compromised, we could do this in camera. If you believe it's not, then we can talk about it publicly.
I'm not worried about the compromising. nature of the affidavit. I will tell the court and make a record that the prosecution has provided Mr. Merson with a copy of the affidavit, despite the fact that it was sealed to the public.
I am concerned about this being discussed in a non-in-camera setting. My concerns revolve around the issues I brought up in the objections to expanded media coverage. It's an ongoing investigation at this point. I have concerns about, what would be discussed and how that would implicate Mr. Watts' right to a fair trial and his due process right. So my request is that the court seal the courtroom so we can discuss this.
Mr. Wright?
Leave that to the discretion of the court.
It seems to me, based on everything I've heard, that the affidavit's going to be released at some point. It was the prosecution who requested the sealing of the affidavit. They're not concerned about this being compromised, the investigation being compromised. And so I think we've talked about this publicly. Mr. Wright?
And when you say talk about this, are we still talking about
Yes.
D-17?
Yes.
Which was also filed under seal.
Yes.
So with respect to paragraph number 3, Judge, our concerns relate to the way this is worded. As the court knows, the pathologist goes through a very extensive process when conducting an autopsy, much of which is governed by statute. I think most of what he's asking for is standard procedure for an autopsy conducted in this jurisdiction and would be done. However, I have concerns about the way this is phrased in that it orders collection of trace DNA and touch DNA from certain areas of bodies that at this point we don't even have, frankly. Second, we don't know if that trace DNA is going to even exist if we have the bodies. So there's no way to order us to find something that may or may not exist.
I think when I read the motion, it essentially is putting the prosecution on notice that at some point they may be in possession of exculpatory evidence, and it's their duty to make reasonable efforts to preserve that and ultimately provide that to the defense. And so I think they're on notice by the mere fact that we're talking about this, that Mr. Wren got a copy of the motion, and if this becomes an issue later on, we can litigate this, and there's some pretty significant sanctions for the destruction of exculpatory evidence. Okay, so that will be the ruling of the court.
Your Honor, may I ask one clarifying question? Because the way that the motion is titled talks about the collection of touch or trace DNA at 2825 Saratoga Trail as well as during the autopsy, but the body of the motion does not. I want to make sure that Mr. Merson is aware that the home where the homicides were alleged to have occurred has been released by law enforcement, was released as of about midnight last night. So even as we stand today, we are not in a position to be able to go back in and collect trace DNA from that home. So I just want to make clear that the ruling of the court does not require us to do anything affirmative with respect to the home.
And Mr. Wren advised me that the government is no longer in control of the home, so I'm aware of that. Thank you.
Thank you.
Thank you.
With regard to the motion for protective order, essentially for nobody to speak to Mr. Watts other than his attorneys and investigators and support staff, I'm assuming there's no objection to that?
Correct.
You'll put law enforcement on notice on that issue?
Yes.
Okay. Any other time-sensitive issues that cannot wait until next Tuesday?
Nothing from the people.
Mr. Merson?
Can I just have 1 second?
Sure.
Nothing further. Thanks, Judge.
Okay, and I would just respectfully ask that if you file anything between now and next Tuesday, certainly into the future, if you could advise your office of this, if there's more than one lawyer working on it, please number every pleading that's filed, and for the prosecution as well, maybe you can use letters. And that way I know that I'm not missing something. That would be wonderful.
Yes.
Okay, so we'll see, let's pick a time next Tuesday. I know everybody's really busy. I just had some time open up. And so what's a convenient time for everybody to be here? I'm also going to be asking if there's victim rights compliance today and see if there's a more convenient time for whoever the victim rights representative is.
we have been in communication with the family of the victims. We are in VRA compliance with that, based on that effort. At this point, we don't have any specific times that are good or bad for the family, but we will certainly contact them as soon as we leave and clarify their availability for next Tuesday.
How about the attorneys? What's a good time for you to be here on Tuesday?
Anytime, Judge. I'll make it work.
The motion's hearing in Division 12 at 2 o'clock. That'll probably last an hour, otherwise I'm free.
How about 10 o'clock?
That's fine.
Okay. So the plan is next Tuesday, 10 o'clock, we're going to know whether the prosecution filed formal charges or not, and the deadline for that would be Monday at 3:30. I will give Mr. Watts a more detailed advisement, and then we'll decide what the next step is going to be. Does that work for everybody?
Yeah, one more thing.
Yes.
I would just ask the court order that the prosecution give the defense notice as to if an autopsy is to be scheduled, when that is scheduled, so that we can file the appropriate motions. I think you can appreciate why we would want notice of that.
Yes. Any objection to that?
Not as to the notice issue.
Yeah, I'm not going to be ordering that they, at this point, I'm not ordering that they be allowed to be present during the autopsy. Why don't we say 48 hours notice? Is that reasonable?
Yes, and if I learn that information over the weekend, I'll email Mr. Mercer.
Is that okay with you, Mr. Mercer?
That's fine, thank you.
They wouldn't do the autopsy over the weekend, though, would they?
No, I don't believe so.
They would?
They're going to try to get it done soon. So 48 hours is probably not going to do it. Because they think they're
We've all certainly seen autopsies scheduled less than 48 hours after the bodies are recovered. So we will do our best to comply with the notice requirements as soon as we learn the information.
Who would be making the decision on when to perform an autopsy?
The coroner's office.
So can you communicate with them that there's an order that there would be 48 hours notice, and if they, for whatever reason, can't comply with that, you'll let Mr. Mercer know?
Is the court ordering that the autopsy not be conducted earlier than 48 hours after the recovery of the bodies?
No.
Okay.
What I'm saying is I'm ordering that you notify the coroner that there's an order that Mr. Mercer is entitled to 48 hours notice, and if they are intending to perform the autopsy sooner than that, they need to let you know before it starts, so you can give Mr. Mercer reasonable notice.
Yes, sir.
Anything else you can think of between now and next Tuesday that we can resolve today?
Nothing from the prosecution.
Nothing from the defense, thanks.
Okay. All right, we'll see you next Tuesday at 10 o'clock. When we are in
If this stillness holds you, a quiet gesture helps sustain these long-form investigations. Taking
Mr.
a
Watts,
moment
why
to
did
like
you
the
kill your
video or
wife and 2 children?
subscribe allows stories like this to be examined with the time and care they demand, bringing hidden truths into focus, one layer at a time.
Good morning, and welcome to be seated. Okay, we are on the record. We are in Division 17 of the Weld County District Court, and we are here regarding Weld County case number 18CR2003, People of the State of Colorado versus Christopher Lee Watts. My name is Marcelo Cuptown, a District Court Judge here in Weld County, and I will be the presiding judge in this case. If I could please have the lawyers identify themselves for the record, starting with the prosecution.
Good morning, Your Honor. Michael Burke on behalf of the people.
Patrick Roach on behalf of the people. Your Honor, John Walsh on behalf of the defense. Jim Burson on behalf of Mr. Watts. Thank you.
Thank you. Mr. Work, do you want to make a record regarding compliance with the Victims' Rights Act?
Yes, Your Honor, we are in compliance with the Victims' Rights Act. Frank Rusick, who is Shanann Watts' father, is present in the courtroom, as is Frankie Rusick, who is Shanann Watts' brother. They are present in the courtroom, and we have advised them of the purpose of today's hearing and what we expect to occur.
Thank you. Mr. Watts, last week I gave you a limited advisement because charges had not been filed. They have now been filed, so I'm going to give you a full advisement. If at any time you have any questions, please let me know, and welcome also to certainly consult with your attorneys, okay?
Yes, sir.
So, you do not need to make any statements. Any statements you make can be used against you. Do you understand?
Yes, sir.
You have the right to be represented by counsel, and if you're indigent, you have the right to request the appointment of counsel or consult with the public defender before any further proceedings are held, and I see that you've taken advantage of that right. Any plea that you make must be made voluntarily and not the result of undue influence or coercion. You understand?
Yes, sir.
At this point, I have denied your right to bail, given the charges. You can certainly have a conversation shortly about that issue. You have the right to understand the nature of the charges. We'll go over them in a moment. You have the right to a jury trial. You also have the right to demand and receive a preliminary hearing within a reasonable time to determine whether probable cause exists to believe that the offenses charged were committed by you. Do you understand?
Yes, sir.
I assume that the defense has received a copy of the complaint and information. Mr. Watts, let me explain to you what you have been formally charged with and what the possible penalties are. Count 1 alleges that on or about August 13th, 2018, Christopher Lee Watts unlawfully, feloniously, after deliberation, and with the intent to cause the death of a person other than himself, caused the death of Shanann Watts in violation of Colorado Revised Statutes 18-3-102, subsection 1, subsection 8, and that crime is classified as murder in the first degree, a class 1 felony. Do you understand? Count 2 alleges murder in the first degree, also a class 1 felony, and it reads that between and including August 12, 2018 and August 13, 2018, Christopher Lee Watts unlawfully, feloniously, after deliberation, and with the intent to cause the death of a person other than himself, caused the death of Bella Watts in violation of Colorado Revised Statutes 18-3-102, subsection 1, subsection 8. Do you understand?
Yes, sir.
Count 3 alleges murder in the first degree, a class 1 felony, and specifically it alleges that between and including August 12, 2018 and August 13, 2018, Christopher Lee Watts unlawfully, feloniously, after deliberation, and with the intent to cause the death of a person other than himself, caused the death of Celeste Watts in violation of Colorado Revised Statutes 18-3-102, subsection 1, subsection 8. Do you understand?
Yes,
Count 4 alleges murder in the first degree, a class 1 felony. It alleges that between and including August 12, 2018 and August 13, 2018, Christopher Lee Watts unlawfully, feloniously, and knowingly caused the death of Bella Watts, a child who had not yet attained 12 years of age, and the defendant was in the position of trust with respect to the victim in violation of Colorado Revised Statutes 18-3-102, subsection 1, subsection F. Do you understand?
sir.
Count 5 alleges murder in the first degree, a class 1 felony. It alleges that between and including August 12, 2018 and August 13, 2018, Christopher Lee Watts unlawfully, feloniously, and knowingly caused the death of Celeste Watts, a child who had not yet attained 12 years of age, and the defendant was in a position of trust with respect to the victim in violation of Colorado Revised Statutes 18-3-102, subsection 1, subsection F. Do you understand?
Yes, sir.
With regard to these first 5 counts, the minimum sentence that the court could impose if convicted is life imprisonment in the Colorado Department of Corrections, and the maximum the sentence is death. Do you understand? Let me also point out that pursuant to Rule 32.1 of the Rules of Criminal Procedure, the prosecutor would have to file a written statement of intent to seek the death penalty no later than 63 days after arraignment. Do you understand? If a life imprisonment sentence was imposed, it would be without the possibility of parole. Do you understand that?
Yes, sir.
Count 6 alleges a Class 2 felony of unlawful termination of pregnancy in the first degree. Specifically, it alleges that on or about August 13, 2018, Christopher Lee Watts, with the intent to terminate unlawfully the pregnancy of a woman, namely Shanann Watts, feloniously and unlawfully terminated the pregnancy of the woman. Further, the woman died as a result of the unlawful termination of the pregnancy in violation of Colorado Revised Statutes 18-3.5-103. Do you understand?
Yes, sir.
The possible penalties, if convicted for this crime, is a mandatory minimum 16 years in prison up to 48 years in prison, followed by an additional mandatory parole period of 5 years. Do you understand?
Yes, sir.
Count 7 alleges tampering with a deceased human body, a Class 3 felony. It alleges that on or about August 13, 2018, Christopher Lee Watts, believing that an official proceeding was pending, in progress, or about to be instituted, and acting without legal right or authority, unlawfully and feloniously, willfully destroyed, mutilated, concealed, removed, or altered a human body, part of a human body, or human remains with the intent to impair it or their appearance or availability in the official proceedings in violation of Colorado Revised Statutes 18-8-610.5. Do you understand?
Yes, sir.
Count 8 alleges also tampering with a deceased human body, a Class 3 felony. It alleges that on or about August 13, 2018, Christopher Lee Watts, believing that an official proceeding was pending, in progress, or about to be instituted, and acting without legal right or authority, unlawfully and feloniously, willfully destroyed, mutilated, concealed, removed, or altered a human body, part of a human body, or human remains with the intent to impair its or their appearance or availability in the official proceeding in violation of Colorado Revised Statutes 18-8-610.5. Do you understand?
Yes, sir.
And finally, count 9 alleges tampering with a deceased human body, a Class 3 felony. It alleges that on or about August 13, 2018, Christopher Lee Watts, believing that an official proceeding was pending, in progress, or about to be instituted, and acting without legal right or authority, unlawfully and feloniously, willfully destroyed, mutilated, concealed, removed, or altered a human body, part of a human body, or human remains with the intent to impair its or their appearance or availability in the official proceeding in violation of Colorado Revised Statutes 18-8-610.5. With regard to counts 7, 8, and 9, those Class 3 felonies carry a presumptive range of 4 to 12 years in the Colorado Department of Corrections. If there were sufficient mitigating circumstances, the minimum could be as low as 2 years. If there were sufficient aggravating circumstances, as many as 24 years. And any prison sentence would be followed by an additional mandatory parole period of 3 years. Do you understand?
Yes, sir.
Do you have any questions about what I've said so far?
Yes, sir.
And Mr. Merston, has your office filed a written intent to seek a proof evident presumptive rate hearing?
Not yet, Judge, but we will be following that. This case will be Mr. Walsh's and Ms. Harrell's. They will be attorneys listed on the, I believe, the most recent pleading from the defense.
Okay, thank you. And I would point out, Mr. Watts, that the prosecution also indicated in the complaint and information that these were acts of domestic violence. Do you understand that?
Yes, sir.
Okay, thank you. And so, Mr. Walsh, what is your request today?
Your Honor, considering that haven't received any discovery of the case. We're not in a good position at this point to advise the court about what kind of time we'll need. My suggestion to the court is that the court allow Mr. Watts to reserve the preliminary hearing in the case, reserve the proof evident hearing, and set the matter for a status conference about 60 days out.
So just to be clear, he is waiving his right to have a preliminary hearing within 35 days, that he's not seeking a proof evident presumption great hearing prior to the setting of the status conference in about 60 days, but he's reserving his right to have those hearings in the future, but not necessarily within 35 days. Is that right?
Yes, Your Honor. We've spoken about those issues.
And do you understand what we're talking about, Mr. Watts?
Yes.
Do you have any questions about that? Okay. And Mr. Rourke, do you have any objection to that request?
No, Your Honor, that seems like the prudent way to proceed at this point.
Okay. Let me give you a date that, how does, so 60 days is about October 20th or so. I have October 11th. Does that date work for the parties? I can go a little bit further if you like as well.
I think a little bit further would make sense, Your Honor. Thank you.
How about November 19th? While we're waiting for lawyers to look, let me make a record that the court's going to find that Mr. Watts is knowingly, intelligently, and voluntarily waiving his right to have a preliminary hearing within 35 days. And while he has not asked for a proof evident presumption great hearing yet, I'm told that he will, but he's not requesting that hearing prior to the status conference that we're setting today. Agreed?
Yes. That date works fine with the defense, Your Honor. Thank you.
Your Honor, I spoke to the Rusiks, and that is fine with the people as well as the victims' family.
How is late morning on November 19th?
Anytime, Your Honor. Late morning is fine.
Very good.
How about 10:30?
That'll work with people.
And I will be in Division 16. I apologize for the bouncing around of division, but my courtroom obviously is not big enough, and I will keep you updated on where the divisions are going to be, but the next court date will be in Division 16. Are there any other questions, comments, concerns, anything that we can address today before us recessing?
I think there are a couple of things outstanding, Your Honor, and first I wanted to address one very ministerial point of clarification with respect to the standing decorum order that the court entered yesterday. By its terms, and when the court defines the applicable areas, that includes my office, specifically the boundaries of the district attorney's office. I just wanted to make a request for clarification that the terms of this order do not apply to the conduct that occurs within my office itself.
Agreed.
Thank you. Otherwise, I have provided a copy of this to the employees of my office, and we will be providing it to law enforcement after this hearing is on.
Thank you. I also intend on issuing a case management order later today, so be on the lookout for that.
I don't know if the court has the desire at this point this morning to address a couple of the other outstanding motions that the Public Defender's Office has filed that we had entered or filed responses to. We have not addressed motions 2, 3, 5, and 7. And those are the defense motions 2, 3, 5, and 7. And for the record, our responses were C, D, E, and F.
I don't have those motions in front of me, but I know that I issued a number of written orders yesterday. Did you receive those?
I received written orders, but not as it relates to those 4, so perhaps they just haven't reached my desk yet.
If they haven't yet, I will issue a written ruling. We'll be getting them shortly. But I issued a number of orders yesterday.
Your Honor, does that include, I did get the order on motion 5 and motion 7. Does that include motions 2 and 3 then that the court would?
Remind me what 2 and 3 are again?
Motion 2 is the motion to allow confidential defense experts to be present for any testing. And we did have a bit of additional argument on that if the court wanted to hear it. Motion 3 is a motion for a protective order.
I prefer they put it in writing, and then I'll issue a written order with regard to that. Is that something that's time sensitive?
I think it could be, Your Honor. I can't speak for the district attorney, but it could be.
I can tell the court, understanding what Mr. Walsh is referring to in motion number 2, it is not something that is going to occur in the next day or two, so it's not time sensitive in that respect.
So you'll be received, if you want to put something in writing, you're welcome to, and I will issue a written order in a timely manner.
Does the court want to give us a deadline for that?
Sure, when would you like to file a response?
I can have it done in a day or two.
Okay. And so, do you have control, Mr. Warren, as to when the testing is going to occur?
Absolutely. I can certainly make clear to our forensic agents that pending the litigation or the receipt of a court order on this, that we will not do any forensic testing.
That'd be great. So did you want to have time to file a reply to the response?
If necessary, if I could have 3 business days to file a response to whatever Mr. Walsh files in the next couple of days, I would appreciate that.
Okay, so Mr. Walsh, do you have something filed by close of business tomorrow?
Yes, sir.
Okay, so close of business on Monday, Mr. Warren?
Yes, sir.
Then I'll have something to the parties by midweek next week.
Thank you.
Any other issues that we can resolve today?
Not for the people, Your Honor.
No, Your Honor.
Okay. Okay, we are in recess. Thank you for your time.
Your Honor, there are no words to adequately describe the unimaginable tragedy that brings us before this court today. By my comments, I'm not even going to try to express the horror, the pain, or the suffering that the defendant has caused to these families, to this community, and to all who were a part of this investigation. However, I do want to spend a few minutes sharing with the court the details of the crime, as so far you've only had an opportunity to review the affidavit and a few facts here and there that have been offered to the court in the motions and pleadings that have been filed. The questions that have screamed out to anyone who will listen since August 13th of 2018 are why and how? Why did this have to happen? How could a seemingly normal husband and father annihilate his entire family? For what? These are the questions that only one individual in this courtroom or on this planet knows the answers to. I fully expect we will not receive the answers to these questions today, nor will we at any point in the future. I don't expect that he will ever tell the truth about what truly happened or why. Even if he did, there is no rational way that any human being could find those answers acceptable responses to such horrific questions. The best we can do is try to piece together some kind of understanding from the evidence that is available to us. And the evidence tells us this. The defendant coldly and deliberately ended 4 lives. Not in a fit of rage, not by way of accident, but in a calculated and sickening manner. Shanann was 34 years old. She had married the defendant in November of 2012. Over the weekend leading up to August 13th, she had been at a work conference in Phoenix, Arizona, and returned home in the early morning hours of August 13th. We know that she got home about 1:45 in the morning. The doorbell camera on their home shows her arriving back home from the airport. Shortly thereafter, at least according to the defendant, they had what he referred to as an emotional conversation about the state of their marriage and about what their lives would look like going forward. What was said during that emotional conversation, only he knows. What we do know is that shortly after that, the defendant strangled her to death with his own hands. We know that he slowly took her life the morning of August 13th. We know that this was not done in an uncontrolled, vengeful manner that he tried to describe to agents from CBI and the FBI. If that were the case, you would expect to see vicious, horrible bruising about her neck, shoulders, and face. You would expect to see the hyoid bone in her neck broken. You would expect to see some kind of defensive wounds on his body as she struggled and fought for her own life. None of those are present. The only injuries that were on Shanann's body were one set of finger or bruising, what appeared to be fingernail or finger mark bruising to the right side of her neck. We know that our experts will tell us that it takes 2 to 4 minutes to strangle someone to death manually with their own hands. The horror that she felt as the man that she loved wrapped his hands around her throat and choked the life out of her must have been unimaginable. Even worse, what must Bella, age 4, and Celeste, age 3, must have experienced or thought as their father, the one man on this planet who was supposed to nurture and protect them, was snuffing out their lives. They both died from smothering. Let me say that again. The man seated to my right smothered his daughters. Why? Imagine the horror in Bella's mind as her father took her last breaths away. Your Honor, understand very clearly, Bella fought back for her life. The frenulum, the connective tissue between her upper lip and her gum, had a 1.5 centimeter laceration. She bit her tongue multiple times before she died. She fought back for her life as her father smothered her. Celeste had no such injuries. In fact, she had no external injuries at all. But according to the medical examiner, she was smothered nonetheless. The defendant then methodically and calmly loaded their bodies into his work truck, not in a hasty or disorganized way. He was seen from the neighbor's doorbell camera backing his truck into the driveway, going back and forth into the house and back out to the truck 3 different times, 1 time for each of their bodies. He then drove them away from their family home 1 final time, intent on hiding any evidence of the crimes that he had just committed. In 1 final sign of callousness for his wife, his daughters, and their unborn son, and their remains, he drove them to a location that he thought no one would ever find them, to one of the oil tank batteries with which he was so familiar. He knew this was safe. He had texted a coworker the night before saying, "I'll head out to that site. I'll take care of it." He had carefully ensured that he would be alone in the middle of the plains to secrete away the remains of his family in a place that he hoped they would never be found. In 1 final measure of disrespect for the family he once had, he ensured that they would not be together, even in death, or so he thought. He disposed of them in different locations. He buried Shanann and Nico in a shallow grave away from the oil tanks. Bella and Celeste were thrown away in the oil tanks at this facility. Different tanks, so these little girls wouldn't be together in death. Imagine this, Your Honor. This defendant took those little girls and put them through a hatch at the top of an oil tank, 8 inches in diameter. Bella had scratches on her left buttocks from being shoved through this hole. A tuft of blonde hair was found on the edge of one of these hatches. The defendant told investigators that Bella's tank seemed emptier than CC's because of the sound that the splashes made. These were his daughters. Significantly, when his coworkers arrived at the tank battery later that morning, to a person, they all described him as acting completely normally. It was a normal workday, even while his daughters sank in the oil and water not far away from him. And then his efforts at deception truly began. We've all seen the emotionless interviews that the defendant gives to the local media, asking for help in locating his family. We watched as he claimed that the house was empty without them, and that he hoped that they were somewhere safe, and that he just wanted them to come home.
He told investigators that they were at home sleeping when he left for work that morning, and that Shanann had told him that she was taking the girls to a friend's house for the day. What is striking about this case, Your Honor, beyond the horrors that I've already described to you, is the number of collateral victims that he created by his actions. While he stood in front of TV cameras asking for the safe return of his family, scores of law enforcement officers, neighbors, friends, and family scoured the area, fretted for their safe return. They texted him begging for any information and sending him their best wishes, all the while he hid what he had done. The list of indirect victims does not end there. Think of the firefighters and the Colorado State Patrol hazmat experts who had to don protective suits and who were called upon to pull Bella and Celeste out of those oil tanks. Or the coroner employees who had to conduct these autopsies. Or the victim assistants who frantically attempted to ease the suffering of those affected. All of this, Your Honor, for what? Why? Why did this have to happen? His motive was simple, Your Honor. He had a desire for a fresh start, to begin a relationship with a new love that overpowered all decency and feelings for his wife, his daughters, and unborn son. While Shanann texted the defendant over and over again in the days and weeks leading up to her death, attempting to save her marriage, the defendant secreted pictures of his girlfriend into his phone and searched and texted her at all hours of the night. While Shanann sent the defendant self-help and relationship counseling books, one of which, ironically enough, was thrown in the garbage, he was searching the internet for secluded vacation spots to take his new love in researching jewelry. And while Shanann took the girls to visit family in North Carolina, the defendant went to car museums and the sand dunes with his new girlfriend. The stark contrast between the subjects of their internet and text content is absolutely stunning. Even the morning after he killed them and disposed of their bodies, he made several phone calls. One was to the school where the girls were supposed to start, telling the school that the girls would not be coming to school anymore, that they were being unenrolled, presumably to give him some more time before law enforcement notification about them going missing. He contacted a realtor to start discussing the selling of his house, and he texted with his girlfriend about their future. None of this answers the questions of why, however. If he was this happy and wanted a new start, get a divorce. You don't annihilate your family and throw them away like garbage. Why did Nico, Celeste, Bella, and Shanann have to lose their lives in order for him to get what he wanted? Your Honor, justice demands the maximum sentence under the agreement reached by the parties. As you will recall, the agreement calls for life sentences as to Shanann, Bella, and Celeste, and all of those to run consecutively to one another. It also calls for the count of unlawful termination of a pregnancy as to Nico to run consecutively to counts 1, 2, and 3. I would suggest that the extreme aggravation present in the defendant's conduct and in the efforts that I have described mandate that the sentences for counts 7, 8, and 9, the tampering with a deceased human body, each be the maximum of 12 years, and that those sentences run consecutively to one another. It is very clear that each of these that these were not the subject of one act, but each oil tank that he walked up with his daughter's bodies and the hole that he dug for his wife and unborn son mandate a mandatory consecutive sentence. It's been alluded to this morning, but the defendant was certainly eligible for the death penalty in this case under the existing law in the state of Colorado. As you heard, Shanann's family strongly opposed my office seeking the death penalty and being bound to the criminal justice system for the next several decades. That's in large part, as you've heard, why we have reached the agreement that we have. 4 lives were lost at the hands of the defendant on August 13th for reasons that we will never fully understand, nor will we know. In the end, the Rusick family was much more merciful towards him than he was towards his wife, his daughters, and his unborn son. Prison for the remainder of his life is exactly where he belongs for murdering his entire family. Thank you.
what I'd like to say to the court is that Shanann, Bella, and Nico are loving, caring people. They love life. They love being around people who love them. They always had good times. This is the first time they went to the beach this year, and they loved it. But God only knows what happened that night. Life will never be the same without Shanann, Bella, and Celeste, and Nico. Had all their lives to live. They were taken by a heartless one. This is the heartless one, the evil monster, who dare you take the lives of my daughters Shanann, Bella, Celeste, and Nico. I trusted you to take care of them, not kill them. And they also trusted you. The heartless monster, and then you take them out like trash. You disgust me. They were loving and caring people. You may have taken their bodies from me, but you will never take the love they had from me. They loved us more than you will ever know, because you don't know what love is. Because if you did, you would not have killed them. You monster, thought you would get away with this. I don't know how. The cameras do not lie. You carry them out like trash of the house. Yes, I seen the videotape. You buried my daughter Shanann and Nico in a shallow grave, and then you put Bella and Celeste in huge containers of crude oil. You heartless monster. You have to live with this vision every day of your life, and I hope you see that every time you close your eyes at night. Oh, I forgot. You have no heart or feelings or love. Let me tell you something. I will think of them every day of my life, and I love them every day of my life. Prison is too good for you. This is hard to say, but may God have mercy on your soul. I hope you enjoy your new life. It's nothing like the one you had out here. May the courts have no mercy on you. It's hard every day. It hurts in so many ways. I have heard people say that you're not a monster. No, you are not. You're an evil monster. Thank you. Love you, Shanann, Bella, and Nico. Love you, Pop and Dad. And one other thing. And Shanann says she is super excited for justice today. Thank you, Your Honor.
Thank you, sir.
The past 3 months, I barely slept because I've been going through a lot of different emotions because I did not see this coming. You went from being my brother, my sister's protector, one of the most loved people in my family, to someone I will spend the rest of my life trying to understand. What gave you the right to put your hands on a woman, let alone my best friend, my beloved sister, your daughters, and your son? Why weren't they enough for you? In the blink of an eye, you took away my whole world, the people that mattered to me the most. Everything in my life I loved, your children. They trusted you. They loved you. They looked up to you because you promised to keep them safe. Instead, you turned on your family. My blood is boiling as I write these last words because they are the last you will ever hear from me. I can't even think of the right words to describe the betrayal and the hate I feel. And to be honest, you aren't even worth the time and effort it takes to put my pen to this paper. There isn't a day that goes by that I don't cry for my family. They were my whole world. All I do is ask myself why. Why would you do this? You don't deserve to be called a man. What kind of person slaughters the people that love them the most? Did you really think you would get away with this? Did you really think that this was your best option, to throw away your family like they were garbage? They deserve better, and you know it. I hope you spend the rest of your life staring at the ceiling every night, being haunted by what you've done. None of us deserved this. Hearing my mother and father cry themselves to sleep in this hotel room causes me anguish that is beyond words. I can't describe how this feels, how badly my heart is breaking for my poor parents. We trusted you. You have taken away my family from this earth, but you can never take them from my heart. You took away my privilege of being an uncle to the most precious little girls I've ever known. I will never hear the words Uncle Frankie again, but you will never be called Dad again either. You'll never be able to put your hands on another woman, let alone my best friend, my beloved sister, and your son. I just can't comprehend how they weren't enough for you. Shanann, Bella, and Cece loved you more than anyone. You were their hero. How could you destroy the people who loved them the most? I pray that you never have a moment's peace or a good night's rest in the cage you'll spend every day of your life in. A cage you are privileged to live in because my family isn't evil like you. We begged the district attorney to spare your life because despite everything, we believe that no one has the right to take the life of another, even someone like you. I feel sorry for your family. I know the pain that they must feel knowing that they can't hug you, because that's how my mother, father, and I feel every time we cry for our family. Nothing hurts more than watching or hearing my family weep for their loved ones. I just wish that I could tell that you would tell the truth, but I know that that is asking for more than you are capable of. I stayed up all night writing this statement. I don't sleep because of you. My life will never be the same because of you, but at least my conscience is clear. I get to live free, but I can't say the same for you. I haven't slept in 2 days because I've been anxiously waiting for this moment, the moment I get to tell you how I feel, how this has affected my family and I. My family and I can finally grieve after today. If anything, we will come out of this stronger today than we were before, and we will continue to pray for your family. Sincerely, Frankie Rusick.
Thank you, Mr. Rusick.
I wanted to say thank you for this moment. I want to take a moment to thank everyone who has prayed for our beloved family, who has sent gifts, cards to us from all over the world. I know God will put the evil people where they need to be. I also want to take the time to thank the town of Frederick, Greeley, FBI, the DA's office, the CBI, for exceptional work. We thank Nicole Atkinson, Shannon's neighbor, Nathan, and his family. To me, they're our heroes. They really are. God bless. God makes no mistakes on who he puts in your life. Marriage is about love, trust, and friendship and unity. We marry for sickness and health, to death do us part. Our daughter Shanann loved you with all of her heart. Your children loved you to the moon and back. Shannon's family was her world. Shanann put a crown on your head. But unfortunately, the day that you took their life, God removed that crown. We loved you like a son. We trusted you. Your faithful wife trusted you. Your children adored you, and they also trusted you. Your daughter Bella Marie sang a song proudly. And I don't know if you got to see it, but it was, "Daddy, you're my hero." I have no idea who gave you the right to take their lives. But I know God and his mighty angels were there at that moment to bring them home to paradise. God gives us free will. So not only did you take the family of four, your family of four, you took your own life. I want the world to know that our daughter and her children were so loved by us. There will always be protected by God and his mighty angels. I didn't want death for you because that's not my right. Your life is between you and God now, and I pray that he has mercy for you. From Shannon's mother, Bella Marie, Celeste, Catherine, and Nico Lee's Nana. Thank you, Your Honor.
I'm Cindy Watts.
Ron Watts.
Thank you. And I have authorized you to make a statement to the court as paternal grandparents of the children. And if you choose not to make a statement, but your designee, Ms. Powers, chooses to, she can do so as well. How would you like to proceed
Can
today?
I read that? I want you to start, but I would like to read
Who's
that.
going to be speaking today?
Your Honor, initially, they've asked me, and they're hoping that they have the strength to speak, but if they do not, they've written out their statements and asked me to finish for them. So
That would be fine. Who would like to go first?
if I could start, Your Honor. On behalf of the Watts, Your Honor, and to the community, we thank you for the opportunity and the recognition under the Victim Bill of Rights. We come today as the grandparents and the parent of the daughter and children whose life was taken in this case. We are not here to ask for leniency. We are not in any way condoning or tolerating the crime that has occurred and the pain that has been caused. We join in our daughter-in-law and grandchildren's family in saying this should never have happened. This is not condonable. This is something that we will never get over. We appreciate the consideration that everyone has paid, most especially the families that have lost everyone. We appreciate that they begged for Christopher's life. We agree and echo what they have said, that it is not his place to take anyone's life, nor would it be our place as a community to take his life. So we thank you for the opportunity and for every consideration and effort that's been put out. The prosecution in this case has in fact respected the Victim Bill of Rights. They took the time to explain that the information that my clients had at the time that they were interviewed was not correct. They were misinformed. They were searching for answers. They were not intending to cause any pain to anyone, and they appreciate that the prosecution answered their questions and gave them the time and the respect and the consideration so that they could tell this court and everyone in this community that the interview content was not their message, that they accept that their son has done this, that they accept that he chose to plead guilty, that he sought and requested their consent and agreement for a life sentence. They appreciate that he is given the opportunity to serve that life sentence. It is his responsibility, it is his sentence, and it is not enough to make up for what has done. We understand and we join the family in that we have questions. We don't know how such a thing could possibly happen, or that a man that was responsible for raising his children and protecting his wife would take the steps that he did, and that he would disregard their bodies and the love that he had for them and they had for him and everyone else, and take the gestures and put this community through the investigation and the discovery and the responsibility of bringing justice. We do not understand that. We do not think it was appropriate. We cannot begin to think that an explanation will ever justify it. My clients indicate that they understand that a full opportunity for a confession with all of the responsibility and accountability has not occurred. And they support the family and the request that that happen, if not today, at an appropriate time, in an appropriate manner, so that everyone can have peace, to understand to the best of their ability the details that they need and to have their questions answered. And by giving this opportunity of a life sentence, we hope that he embraces that moment. That had the death penalty been pursued, there would not have been an opportunity to be accountable and to give a full confession. And had the death penalty been sought, counsel would have fought for his life, the prosecutors would have been engaged in a multiple-year battle, the families would have been torn apart, this community would have had to subsidize it and endure it, and we have so much respect and gratefulness that that did not happen. We would strongly encourage Christopher Watts to give that full confession in the tone and in the timing that he thinks is appropriate with the guidance of his counsel. We feel that it would be appropriate and helpful to ease the pain and the suffering. But we also say we don't think that there's anything that he can say that will ever account for his behavior. There's nothing that can be done to cure the harm he has caused. And he has the responsibility to serve his sentence with dignity and with regard for everyone, and to spend every breath that he has left in an atonement for what he has done. Do you want to read it?
If I could just have you state your name for the record.
Cindy Watts.
Thank you.
My name is Cindy Watts. I am the grandmother of two beautiful granddaughters, Bella Marie, Celeste Catherine Watts. I am also the mother of Christopher Watts, who I will be directing most of my statement to. First, I'd like to begin by recognizing the absolute horror of this crime and acknowledging the devastating loss that both the Rusek family as well as our family have faced. Our families have been irreparably broken by the needless deaths of Shanann, Bella, Cece, and Nico. This is something we will never get over. We will always mourn the loss of our family, and in that, we are united in our grief. I am still struggling to understand how and why this tragedy occurred. I may never be able to understand and accept it, but I pray for peace and healing for all of us. Now to my son Christopher. I have known you since the day you were born into this world. I have watched you grow from a quiet and sweet, curious child who Bella reminded me so much of, to a young man who worked hard in sports and later mechanics to achieve your goals. You are a good friend, brother, father, and son. We have loved you from the beginning, and we still love you now. This might be hard for some to understand, how I can sit here under these circumstances and tell you, although we are heartbroken, although we can't imagine what could have led us to this day, but we love you. Maybe you can't believe it either. As the Lord said in Jeremiah 3:31, I have loved you with an everlasting love. Therefore, I have continued my faithfulness to you. And you, as your mother, Chris, I have always loved you, and I still do. I hate what has happened. Your father and sister and I are struggling to understand why. But we will remain faithful as your family, just as God remains faithful because of his unconditional love for us all. We love you, and we forgive you, son.
Thank you.
Judge, if I could read Mr. Watts' statement.
Yes.
My name is Ronnie Watts, and I am the grandfather of Bella, Celeste, Nico Watts, and I am the father of Shanann. I am the father of Christopher Watts as well. And one of the most important things I've done in my life is to raise my children and to watch as they started their own families. I spent many years coaching Little League and talking to my son, taking him to the races, and sharing my love and knowledge of cars with him. He was just as involved with his girls. I believe he loves his girls. I know he does. This tragedy has impacted my family in so many ways. Beyond losing my precious grandchildren, our beloved daughter-in-law, we are forced to question everything. We still don't have all the answers, and I hope one day, Christopher, you can help us. Chris, I want to talk to you as a father and son. You are here today accepting responsibility, but I want to tell you this now. I love you. Nothing will ever change that, and I want you to find peace, and today is your first step. The Bible says if we confess our sins, God is faithful and just and will forgive us. Chris, I forgive you, and your sister forgives you, and we will never abandon you, and we love you. Dad. Judge, thank you for the opportunity to address the court.